Closing arguments have been delivered in the largest antitrust trial in the United States in 25 years. Now the wait for a ruling begins. The Department of Justice in the U.S. is alleging that Google's search engine has become a monopoly, stifling competition and innovation. It says a $10 billion deal between Google and Apple is unfair. That deal makes Google the default search engine on smartphones. For its part, Google says customers use their search engine because it's simply the best option. A ruling is not expected until late summer at the earliest. If Google is found guilty, another trial will be held to determine how to rein in Google's influence. Other tech giants like Meta, Amazon, and Apple are following this case closely, as a ruling against Google could have significant implications for them. And joining us to discuss the trial is Rebecca Allensworth. She's a professor at Vanderbilt Law School who studies antitrust, and she's in Nashville. Now, thank you for joining us. For people who haven't been following this case closely, can you briefly explain what's at the heart of it?
So at the heart of this is a claim that Google has exclusive dealing contracts with mobile device makers like Apple. And it's not exactly exclusive, it's a default. So they pay actually more than twice the figure you said. It's actually over $20 billion a year to Apple to be the default search on the iPhone, for example. What that means is that other search engines like Bing or DuckDuckGo can't really have access to iPhone users almost at all. It is possible to switch from default, but consumers very rarely do that. And the claim is that Google is doing that because it doesn't want Bing and DuckDuckGo to get the scale and access to consumers that it needs to really compete with Google search.
And what exactly is Google's defense that it's presenting?
Well, Google says that we're big and we're the biggest because we're the best. And even if you did give consumers a choice, which consumers do have a choice, they can switch away from the default, they're not going to switch to Bing and DuckDuckGo because they're just not as good. And also they claim that competition is just a click away. So we're bigger because we're better, and you can always switch if you want to. That's essentially their defense.
So what are some of the possible outcomes in this case?
So, I mean, the government could lose. The government could lose either on the monopoly power point. In America, you have to have two things to prove a monopolization claim. One, you have to show that the company has monopoly power, which means a very high degree of market power. And then two, you have to show that they maintained it or obtained it using an unlawful exclusionary act. Here, the government has very strong arguments that Google is a monopolist. Google is fighting this and they're arguing about it, but it does seem like it's hard to believe that Google really has a lot of other major competitors in search. And the judge seems kind of skeptical of that too. But the other thing that the government has to do is they have to win the bad acts. And so if they win on both of those prongs, if the court finds that they're a monopolist and they got it or maintained it by using exclusionary acts, there'll be a sanction. It could be a breakup, but I really doubt it. I think it's possible the government will ask for this, but I think it's really unlikely to happen. More likely, the court would say, you know, you have to stop doing what you're doing now. You have to stop these exclusive dealing, de facto exclusive dealing contracts and distribute your search product in a different way.
Do you think a potential solution might be that when you get a new smartphone, one of the first things it does is ask you who you would like as your search provider?
I think that's right. I think a choice screen is really the most logical way to remedy the allegations at the heart of this case. The problem with that, of course, is that we all know who's going to be chosen. We all know who we would choose in most cases, and that's going to be Google. And so there's a question as to how much that remedy really will solve the problem and open up competition. At the same time, we know that Google is paying tens of billions of dollars a year for that not to happen. So it must be valuable to them.
And what implications could this have on other tech companies like Meta, Amazon, or Apple?
So obviously, all of these companies are in the crosshairs of the government. They are, as you say, watching this closely. And there's a bunch of issues in this case that are potentially relevant to those other companies. So, for example, this is a zero price market case, as in we don't, as searchers, pay for search directly in dollars and cents. Well, that's also true about most of Meta's products. Most of us consume social media without actually paying in dollars and cents. And so things that the court decides about market definition and about monopoly power in a zero price market in this case will matter for a case like Meta. I'm also interested to see how much the court seems to care about intent evidence. Did Google try to monopolize the market, and were they aware that what they were doing was bad? Because there's a lot of evidence in all the other cases against those big tech companies about the intent to monopolize.
Well, certainly interesting, and we will be watching. Rebecca Haw Allensworth in Nashville.